I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being. Can I at least have you admit that in the court of law that you guys illegally kidnapped me again?
I'm Antoine in the natural form, flesh and blood, right here. How you doing?
So you're Antoine Latney, right?
No. Are you referring to the all capital name?
Bro, we trying to go. You making this shit longer than it gotta be.
I know it.
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff.
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there.
Who are you?
Living man.
Well, if you're talking to me, I suppose you're living. I hope you're living, unless I'm assuming there's nothing funny. Who are you?
My name's Roman, sir.
Court calls case people versus Jade Lathan.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt.
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade Ruth Ann Lathan and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation, this matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, I mean, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay, I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for
June 6th at 9 a.m.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Welcome.
All right, Mr. Casanova, you want to come forward? Yes. Hello, how's it going?
It'll be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I am the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me.
Mhm.
There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
Deputy Laura, do you know if he's been served with the indictment yet?
I'm not sure.
All right, thank you. So we're back on the record in 2024 CR 2974, State Vex versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that would be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, Can you call managed assigned counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right, well, I don't know how I can further make you understand.
Are we on the record?
All right, Norma, get someone from managed assigned counsel here, please. All right, just have a seat and we're gonna have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no, let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from managed assigned counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
the accused
Just
in
one
the
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
All right, and
Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the Admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under. Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm going
Admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat. Managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat. Thank you. Yes.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay, all right, and so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So,
All right, we're gonna go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you come forward. Yes. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
All right, I think that's our last case for the day. Is that correct? All right, thank you for coming over, Mr. Bach.
yes, Judge.
All right.
Daniel McDonald,
Here in regards to that matter, sir.
excuse me.
I'm here in regards to that matter.
Okay, are you said I'm here. Who is I? Who are you?
Living man.
Well, if you're talking to me, I suppose you're living. I hope you're living, unless I'm assuming there's nothing funny. Who are you?
My name's Roman, sir.
Roman?
Yes, sir.
Oh, are you an attorney?
Yes, sir.
Well, unless you're an attorney, you don't need to represent Mr. Daniel McDonald. You can have a seat. You said Roman,
Yes, sir.
and you're not an attorney?
Yes, sir.
What's your relationship to Mr. McDonald?
Depending.
Are you representing Mr. McDonald?
Yes.
But you're not a member of the Florida Bar?
Yes, sir.
Are you a member of any state bar?
Yes, sir.
Did you go to law school?
Yes, sir.
So how are you representing Mr. McDonald?
I would just like to ask some questions in regard to that matter, sir.
You can answer my questions regarding that matter. What's your last name?
McDonald.
So your name is Roman McDonald?
Yes, sir.
And are you related to Daniel McDonald?
I just go by Roman, sir.
You just told me that. Are you related to Daniel McDonald?
Yes, that the name on your docket is in relation to me. Yes, sir.
Well, you stood up, so I'm assuming it's in relation to you, but you're not, are you Daniel McDonald?
Yes, sir.
Come on up, Mr. McDonald. That's nothing funny. We don't have time for these games. Come on up.
I just go by Roman, sir.
Well, all you had to do is say I'm Mr. McDonald. You didn't have to say I'm representing him. I'm related to him. All you had to do is say I'm Mr. McDonald and come
I
forward.
apologize for the confusion. sir.
Okay. Has the state filed an information in this case?
No one calls me Daniel.
One moment. Has the state filed an information in this case?
Not this time.
All right, Mr. McDonald, we will see you next month for an arraignment, November 12th at 9:30.
Sir, I haven't entered any type of plea.
I know the state hasn't filed an information. It's not time for you to enter a plea. If the state decides to file an information, you can enter a plea at that time.
Can I motion for dismissal right now based on procedural grounds?
There's nothing to dismiss. The state hasn't filed an information. What are you dismissing?
That I put in an affidavit and a demurrer, a motion to dismiss, and it hasn't been responded to. I think the state attorney has 15 days to respond to that motion, and they have not.
A motion to dismiss what?
The cases, the matter.
The state hasn't filed an information. There's nothing to dismiss. There's nothing to respond to. If the state decides to file an information, you can renew your motion to dismiss. If you're going to represent yourself, Mr. McDonald, and if so, I'll ask you a few questions. But right now, the state hasn't filed an information, so we'll come back November 12th at 9:30, okay?
Sir, I got two more questions if you don't mind.
Yes, sir.
Is there a verified claim against me?
A verified claim?
Yes.
I'm assuming you're talking about an information. The state hasn't filed an information. That's under oath and is verified.
Are there any orders? Can I be released the orders of the court?
Were you arrested?
Yes,
You're not in jail?
correct.
You were released on orders of the court already.
Is there anything additional orders of the court, or just waiting on the prosecutor to file additional information?
Right. Not an
Before anything
additional
else happens.
information. We're waiting on the prosecutor to decide whether or not they're going to file formal charges in the form of an information. If they do, you can enter your plea. And if you want to file a motion to dismiss, we'll set it for hearing.
Is there any reason why they hadn't filed any already?
That's none of my concern. They have a statutory period of time to file an information. And if that time comes or goes, we'll address it. But right now, they haven't filed an information. If you hire an attorney, your attorney can reach out to Mr. Patterson. If you want to represent yourself, I'll ask you a few questions next month and you can speak with Mr. Patterson about it. More likely than not, for self-represented litigants, attorneys, prosecutors only speak to them on the record. So we'll come back next month at 9:30, okay?
Sir, my only problem is I live 6 hours away.
Oh, all right. You can always hire an attorney and they can file a notice of appearance and written plea of not guilty for you. If you want to seek the services of the public defender's office, you can fill out an application. The clerk will determine whether or not you're indigent. And if you are, I'll appoint the law office of Henry Mark Sims to represent you. And Mr. Hill knows exactly what he's doing. He can contact my office and file a waiver of presence or ask that you appear by Zoom. But right now, we'll come back November 12th at 9:30.
I would, if there's any way possible, I'd like to handle these matters today.
Handle what matter?
Any matters in regard to that name. And I know you have business to attend to, so I
Yes,
won't
sir.
hold you up, but
Well, you're not holding me up. We are attending
it's
to,
not easy to take 2 days off work to be here and then nothing happened. You know,
well, I just told you what you can do. So we'll see you November 12th at 9:30.
like
You can sign this notice.
Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay. What's the announcement?
Judge, it's my understanding that Ms. Pugh and her family has retained an attorney on this matter. You may, I don't know if you remember, Judge, this is when I was originally appointed on, and we were on the trial docket. She hired a new attorney at that point. Mr. Norwood, who was on the case for a while and then withdrew. And once recently, when the case came back to me, I visited with her and was told that they did retain another attorney. I was given the name of Christopher Wiley this morning, but I have not heard from him. And my understanding is that at this point still hasn't filed anything with the cool.
Okay,
But I've been told that that's who's supposed to be taking over the case.
okay.
For the record, I recognize Ms. Q, she's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Q's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself? Or are you going to let Mr. Lewis represent you? Or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel, defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pugh. I appreciate your position, but listen, Ms. Pugh, don't speak over me. Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
Or comply to your appointed
Go back.
agents.
You already said that, and that's overruled. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Right. Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you are expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea what they want.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list. This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
All right, so we have Mr. Peltola here.
Ma'am, I'll
you
give
hear
you
me?
my name and prove charges exist. If not, I'll step behind the bar underneath copyright law.
All right, hold on. I'll call your case and I'll give you the floor.
Just page 1.
Just page 1, if you would, please. Thank you. All right, people of the state of Michigan versus Drew James Peltola, files 247831 SM and file 247819 SM. Mr. Peltola appears from the Dickinson County Jail.
The
Counsel
appellation
at,
known as Drew James Peltola appears before you as an entity.
hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file. as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond
Oh, wait,
violation was.
wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
All right, is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off of drugs and try to maintain my court dates.
All right. In regard to the matter then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, that your objections in respect to the court's jurisdiction and whatnot are noted for the record concerning your position regarding your status with the court. All your rights are preserved. In regard to the matter, did you understand the advice of rights and plea information form as it was then, Mr. Peltola?
Yes, I did, Your Honor.
How about the bond violation arraignment hearing form? Did you understand that?
I do not have it in my hands, but I read it, and yes, I fully understand.
All right, it's signed by you, today's date. Did you sign it?
Yes, I did. I also brat. Yes, I did, ma'am.
All right, then, in regard to the matter, I also have a waiver of extradition here. I'm going to just go back over what it means to sign one of those. And let me start by saying, so long as you come back to court voluntarily for all your court appearances, this does not become relevant. But if you didn't come back to court, normally you're entitled to what's called an extradition hearing before you are returned to Michigan. And the purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan to fight the underlying charges. And the bond violation, now with the new bond violation, are we going to set both bond violations together, or do you want to proceed on the first one today?
I would like to set both of them together, I think, in the interest of justice. And prosecutor had made an offer on the original file, and I think they will be making a new offer. And I think in light of that, it would be best to adjourn those matters on violations in that file.
So we have a jury trial set for March 8th in that matter. All right, did you wish to be heard on bond then on the newest bond violation as well as the new underlying charge?
Yes, Your Honor. Actually, the newest bond violation predates the previous bond violation. The first bond violation is alleged to have occurred on February 22nd. This current bond violation that is being rained on today is alleged to have occurred on February 19th. And in light of that, I would ask the court to consider setting either a reasonable bond or, again, a PR bond. In discussing this matter with Mr. Peltola, he does have criminal matters pending in Brown County, and there is a court date on Monday in that case. It looks like from the lien printout, he may have had some issues either in the past or currently appearing in court. And I'd like to be able to have Mr. Peltola be able to take care of that matter. It looks like it's a more serious matter than the matters in this court. If he can make those arrangements to get down to Green Bay to take care of that. He's given me the name of his attorney, and I intend to contact that attorney and see what Mr. Peltola needs to be doing with regard to that case. So if the court does not grant a bond that he can post, perhaps we can make arrangements for him to appear from the jail here.
All right, concerning the matter then, I have some concerns regarding Mr. Peltola. he seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case, total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond concerning the new theft case. Then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney. If
in residency, he lives in Wisconsin.
in residency, no, he lives in Vulcan, or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My residency and my domicile.
And that's your mailing address, though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got 2 issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your mother's house is, Mr. Peltola. In regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release them on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at $2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in
Can I say
custody,
something?
she'll be in touch with you. You may.
Can I say- Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your.
Can I at least tell you that I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
This is the city of Detroit versus Antoine Pierre Latney. His number SP 1445437 SP 162203661, SP 1627402, counts 1 and counts 2. Appearance for the record, please.
Sherika Harris, on behalf of Mr. Latney, please state your name for the record.
Here's a special appearance. Here's the bond in question, the birth certificate. I'm the natural person, natural man, and I'm not surety for this bond here, but I got it right here in my hand.
You have to turn your first of all, Mr. Latney, you have to turn your camera on. I can't talk to you without seeing who I'm talking to.
And I withdraw my appearance, Your Honor.
Why do you withdraw your appearance so quick, Mr. Harris?
Because it appears he does not need the assistance of counsel.
Well, we don't know that yet.
I should start my video, but it's doing something like.
Mr. Ostrowski, you might want, I don't know if that's a cigarette. I would take that out if I were you. Good job.
It says start your video, so you got to start your video, all right?
I'm going to use my phone, I guess.
Are you all right? Well, however you do it, I'll pass the matter until you get it together, all right?
All right.
Let's go back on the record with Latney. So, Mr. Latney, state your name for the record, please.
I'm making a special appearance. I'm Antoine, the natural man, and here goes his topography, all capital name, Antoine Pierre Latney bond that you guys are questioning. I'll make a special appearance on this.
Mr. Latney, I have no clue what you're holding up or what you're talking about.
Yeah, that's the birth certificate. I'm holding up the birth certificate of Antoine Pierre Latney.
Okay, and who is Antoine Pierre Latney?
That's I'm the natural person, but the all capitals name, which is topography that you are dealing with the all caps, that's his birth certificate. I'm not that all capital name. The all capital name is his birth certificate right here. I'm the natural person.
I don't know what you talk about. You're confusing me.
I'm confused too. I'm confused too.
Okay, well, we're both confused. I need to see Antoine Pierre Latin. That's who I need to see.
I'm Antoine in the natural form, flesh and blood, right here. How you
Okay,
doing?
so you're Antoine Latin, right?
No. Are you referring to the all capital name?
Bro, we trying
I
to go.
don't
You
know what
making
you're
this shit
talking
longer than
about.
it gotta be,
I
gang.
know it.
I'm gonna pass the matter until I get Antoine Latin.
Okay.
All right. Let's go Latin. Let's get this over with. Yeah, let's do this because it's gonna linger on. And Mr. Latney, let's go back on the record with Antonio and Antoine.
For the record, I'm making a special appearance. I'm Antoine Pierre Latney, and I'm making a special appearance for this bond. I do not assume any responsibility for the all capitals name that you guys have in front of you or anywhere else.
Your Honor.
Yes.
All right, I'm gonna put my appearance back on the record. Cherika Harris, on behalf of the natural person, Antoine Latney, and I will ask for a breakout room, but I am ready on Johnny Gatewood if we could do that matter first.
We'll get Johnny Gatewood out of here. But you know something, Ms. Harris, I don't know if Mr. Latney knows that we get a lot of attention from these bloggers and these
it's just that it's like I drive for a living, but when I get into my regular car, I
Mr.
don't get
Latney,
paid.
Mr. Latney, if I were you, I wouldn't talk. I mean, well, I'm sorry, you might not be Mr. Latney, but the person representing, I wouldn't talk if I were you. Give me a moment to speak with you in the breakout room before you make a whole lot of statements on the record, please and thank you.
Oh.
Okay. All right. So let's I'm gonna put you in a breakout room, Mr. Latney. Have a conversation with you don't object to that, do you? Having a conversation with Ms. Harris?
No.
So have a conversation with Ms. Harris and then just wait on her. I'm gonna get Mr. Gatewood out of here and then we'll hear what you have to say, all right?
Yes, sir. That's great.
All right, let's go back on the record. Let's go back on the record with Latney. Mr. Latney, what is this? How is this dismissed, Ms. Harris?
Your Honor, I've had an opportunity to speak with Mr. Latney. I was able to ascertain that he does have insurance that expires December 2nd, 2024. He did show me his receipt. Mr. Bowman was kind enough to take the receipt for the registration. And he also showed me his Georgia license that was issued in January of 21 and expires March of 29. My understanding is that would take care of the matters that were before the court. We would ask the court to adopt the recommendation to dismiss.
All right. If that's the recommendation, we will adopt it and to get Mr. Latney on his way. Because I don't know how you check a Georgia license, but we'll adopt the recommendation. Mr. Latney, you still owe $174 for an expired plate, a old expired plate, and $108 for an old no valid registration, all right?
Your Honor, if I can inquire as to how old those are?
They're too old for me to set aside. I can give you the date, but I'm not going to set it aside.
Thank you, Your Honor. I thought I would try.
Yeah, you can't help but try. That was the last year, April the 8th. Dismiss for providing
Thank you, Your Honor. Mr. Latney, those matters were dismissed, but you do have some that still have to be paid.
All right. Mr. Latney, you understand that?
What's the criteria?
No, you just owe 2 old civil infractions that you never paid. An expired plate and the no registration, $174 and $108. The other matters that the court calls into the record are dismissed, all right?
Okay.
All right, have a great day, sir. Best of luck to you.
Thank you. You too.
Good job, Ms. Harris.